Thank you for attending this session of Tennessee Medical Association's Spotlight videos. Today's video will discuss the law passed by the 2015 Tennessee General Assembly that allows a group practice to be paid for services provided by the provider applicant while the credentialing application is pending. This new law permits physicians going through the credentialing process with a health plan to be reimbursed for services provided to the health plan members during the credentialing process. Special thanks go to the sponsors, Senator Richard Briggs and Representative Brian Terry. Both sponsors are physicians and members of TMA. The law is located in Section 56.7.1001 of the Tennessee Code and is effective on January 1, 2016. Tennessee commercial plans are required to provide any medical group practice with which the plan has an existing contract a list of all information and supporting documentation required for a credentialing application to be considered complete. It also creates a process by which a provider or practice may be paid for services provided by the applicant while the credentialing application is pending. Only credentialing applications submitted on or after January 1, 2016 are eligible for the payment of services provided while the application is pending. The law only applies to Tennessee commercial health plan credentialing and physicians and other healthcare professionals providing services in medical group practices. The law has no applicability to hospital or other facility credentialing. The law does not apply to the TennCare program, Cover Kids, Access Tennessee, or any other plan managed by the State Department of Finance and Administration. The law does not apply to federal programs either, such as Medicare, Medicare Advantage, or TRICARE. There is a timetable associated with this law. It starts when the new provider applicant submits his or her credentialing application to the health plan. Within 5 business days of receipt of the application, the health plan is required to provide written notice of the status of the application to the medical group practice. The notice must indicate whether the health plan considers the application complete or incomplete. If the application is considered incomplete, the health plan's written notice must include a list of all the information that is missing. If the medical group practice receives the written notice that it is incomplete, the practice must provide the missing information within 30 calendar days of the notice. Otherwise, credentialing is discontinued. If credentialing is discontinued, the applicant must start the process over. In addition, if a new provider applicant fails to submit a complete network participation enrollment form, including signature evidencing intent to participate with the group, and any other required documentation within 30 calendar days of the notice, then the new provider applicant may not be eligible to receive retroactive payment for services rendered once that credentialing application is approved. If the missing information is provided to the plan within 30 calendar days of the notice, then the plan has 5 business days to notify the medical group practice in writing whether the application is considered complete or incomplete, and if incomplete, what information is still needed. If the medical group practice receives the written notice that it is incomplete, the practice must provide the missing information within 30 calendar days of the notice. Otherwise, credentialing is discontinued. If credentialing is discontinued, the applicant must start the process over. In addition, if a new provider applicant fails to submit a complete network participation enrollment form, including signature evidencing intent to participate with the group, and any other required documentation within 30 calendar days of the notice, then the new provider applicant may not be eligible to receive retroactive payment for services rendered once that credentialing application is approved. If the missing information is provided to the plan within 30 calendar days of the notice, then the plan has 5 business days to notify the medical group practice in writing whether the application is considered complete or incomplete, and if incomplete, what information is still needed. Once the application is deemed by the plan to be complete, the plan has 90 calendar days in which to notify the provider applicant of the plan's decision on the credentialing application. Keep the date of completion in mind. It will be important if the practice needs to later submit claims for dates of service during which the application was pending. The completion date starts the potential payment period. Once the application is approved, then submit the claims for covered services provided between the date the application is deemed complete by the insurer and the date it is approved. The reimbursement must be at the contracted in-network rate. Only submit claims for services provided on behalf of the group. If the new provider's start date is after notification that the credentialing application is complete, then that is the date of reference for payment of claims. Submission of claims from a former practice or another practice setting are not covered by this law. Health plans can recoup money from the practice if credentialing approval was obtained by fraud. Amounts not paid for claims for dates of services during pendency of the credentialing application cannot then be billed to the plan's members. In other words, no balance billing. Remember, do not submit claims for the provider that is in the credentialing process until the application is complete and accepted by the insurance plan. If this provision is violated, the plan can deny the claims. If the health plan denies the credentialing application or does not wish to contract with the provider, retroactive claims will not be paid. The law does not require a health plan to credential and contract with all providers who submit complete credentialing applications. Currently, there is no penalty for health plans who violate this law. However, consistent or habitual violation by health plans could justify amending the law to add one. TMA members who believe that a health plan has violated this law should contact the TMA legal department. The law's applicability to recredentialing is unclear. The use of the term new provider applicant in the law would lead one to believe that the law does not apply. However, some plans might not interpret the law that way. Members experiencing problems with recredentialing or reports of plans taking the position that the law does not apply to recredentialing should contact the TMA legal department. Be careful. The law does not specify as to whether the 30 days begin on the date listed in the notice document or whether it begins on the date the provider actually receives notice. TMA recommends that providers assume it's the date listed on the notice unless the notice specifies otherwise. This is because the health plan will have no way to know when the notice is received by the new provider applicant unless the plan sends the notice via registered mail. Likewise, TMA recommends that the new provider applicant and the medical group practice assume that the 90-day clock in which to make a decision on the credentialing application starts on the date listed in the notice, unless otherwise stated. Health plans have been known to play fast and loose with dates on correspondence. This can be especially egregious when matters of payment are at stake. For example, contract amendments dated November 1, which gave practices 30 days to accept or reject an amendment, have sometimes been received by practices within only a few days of the deadline. Be cognizant of this practice and pay close attention to dates on the notices. Report any abuses to the TMA legal department. The law does not specify the manner in which notices must be sent by the health plans to medical group practices. It just requires that those notices be in writing. If credentialing application instructions do not tell the applicant how the notices will be sent to the practice should contact the plan to find out whether it should be looking for a letter, email, fax, or other form of communication. The law requires that the notices be sent to the medical group practice, not the new provider applicant. Plans may inadvertently direct notices to the applicant instead. If the new provider applicant is at a different address than the medical group practice, this could cause problems and would be a technical violation of the law. Medical group practices should request that the new provider applicants immediately share notices received with the practice. The TMA legal department should be notified if a health plan directs notice correspondence required by this law to the new provider applicant rather than the practice. If you have any questions about anything we have said in this spotlight, please contact the TMA legal department at legal@tnmed.org or call us at 1-800-659-1862. You can also visit our website at www.tnmed.org for continuous updates on the credentialing law and any other laws or issues affecting the practice of medicine in Tennessee. We also have an extensive law guide with over 150 topics related to the practice of medicine, including one on the 2015 credentialing law, which you can find at the link printed at the bottom of your screen. This resource is for TMA members only, so you will need your member ID and password to access any of the law guide topics. If you are not a member and are interested in joining the TMA, please visit our website to learn more and begin the registration process. Thank you for joining us for this session of TMA Spotlights.